Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is Tuesday, November the 30th. It's 10 a.m. and we're here in docket number 2014-346-WS. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Caston, Powers, and Thomas. Joining us virtually, we have Commissioner Urban. Attorney Butler, if you would, please, sir, read the docket.
Yes, sir. Good morning, Mr. Chairman and other members of the commission. Before you today are oral arguments in docket number 2014-346-WS related to the issue of proposed reparations for Daufuskie Island Utility Company, Incorporated. These oral arguments are being held pursuant to Commission Order number 2021-581 and are scheduled for today, Tuesday, November 30th, 2021 at 10 a.m. before the commission. Mr. Chairman and other members of the commission, the docket is in order.
All right, we'll take appearances from the party, Daufuskie Island Utility Company.
Good morning, Mr. Chairman. Tom Gressett on behalf of the applicant, Daufuskie Island Utility Company.
All right. Interveners.
Mr. Chairman and Commissioners, I'm Jack Pringle on behalf of the POA interveners.
All right. Thank you for being here. Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the Commission. Andrew Bateman representing ORS. Thank you.
All right. Gentlemen, is there anything we need to discuss before we begin our arguments?
No, sir.
All right. Applicant.
Thank you, Mr. Chairman. Again, I'm Tom Gressett here on behalf of the applicant, Daufuskie Island Utility Company, Incorporated. As the commissioners are aware, this case has been pending for a while, since 2015, when the utility made its original application for a rate increase based on a test year of 2014. Based upon those numbers, the application proceeded to hearing. A first order was entered. There was an appeal, reversal. In that reversal, the Supreme Court made a specific holding regarding Parker versus South Carolina, wherein it stated, "We now hold that a remand to the commission for a new hearing necessarily grants the parties the opportunity to present additional evidence. Rate cases are heavily dependent upon factors which are subject to change during the pendency of an appeal. Thus, it serves no purpose to bind parties to evidence presented at the initial hearing, which may no longer be indicative of the current economic realities on remand." With that language and other specific instructions from the court, the commission held a rehearing, entered an order, and that order also was appealed and reversed. In reversing that commission order, the Supreme Court addressed how ORS handled certain standards of evaluating evidence on rehearing versus how it was handled on the initial hearing. After the case came back to the commission, there was discussion among the parties regarding whether an additional hearing was necessary, what that should involve, how we should conduct that. After the applicant filed its initial testimony, the parties were able to come to a settlement, which was approved by the commission, and part of that settlement included a provision that the proceeding would remain open for the parties to address the issue before you today. Quite simply, that issue is when an applicant files for a rate increase and through no fault of its own, proceeding is extended extraordinarily, in this case for 6 years. Does the commission have the right to, and should it, implement rates that allow the utility to be made whole for the periods of time when it was allowed only to collect rates that are constitutionally insufficient? Rates that are, as the commission knows, sufficient are rates that allow a utility to attract investors, to earn a reasonable return. When rates do not allow these, they are constitutionally improper. It seems then that where we are is on remand in the same proceeding that has been pending since 2014. So there's no finality to this proceeding until we complete any necessary or pursued appeals. In that proceeding, following the second remand, the applicant has asked this commission to consider the economic realities that the utility has faced by virtue of the extraordinarily long time of this case and the impact that has had on its ability to earn proper rates. In other words, the length of this case has resulted in a constitutional deprivation of the utility's right to earn an adequate, constitutionally sufficient return for the periods discussed in the pleadings. And therefore, before the docket is closed, the applicant is asking the commission to address those shortcomings in a final order in the docket. I am happy to answer any specific questions the commissioners have. I am also happy to discuss any of the issues in the case. I feel like there has been a lot of time that the commission has permitted the parties in this case, and I want to be respectful of that and provide the commission the information necessary, but not any more.
All right, thank you, sir. Intervener?
Mr. Chairman and commissioners, am I sounding okay? I'll lean in a little bit. This case has had some history to it. There are a lot of facts and allegations that have been raised in the various briefs and proposed orders. But the key to what this commission should do and is required to do by specific and clear and unambiguous South Carolina law, statutory law, that's been confirmed by our Supreme Court and this commission on a number of occasions, is based upon what rates have lawfully been in effect and the rate-making process that has taken place over the course of this case. Rate-making is prospective. That means rates are set going forward. When this commission hears a water and sewer rate case, it does consider a test year, as Mr. Gressett mentioned, often considers expenses and other events that may take place outside the test year, considers the evidence, and makes a ruling that sets a rate based on assets, expenses, returns on equity, and other factors, and then sets a rate. South Carolina law makes clear that that's prospective, going forward, not going backward. And the term retroactive rate making and the practice of retroactive rate making is prohibited specifically by South Carolina law, as confirmed by the South Carolina Supreme Court. And so, but in order to sift through all that, and this is all in the brief and proposed order, is to look at what rates have been lawfully in effect during the course of this case and whether or not these appeals and the reversals by the Supreme Court changed those lawfully approved rates or directed the commission to change those lawfully approved rates. And the Supreme Court did not. The appeals, the result of the appeals did not change the rates that were approved by the commission in the first case, which were actually never went into effect because DIUC bonded its proposed rates and had those rates in effect. No Supreme Court decision invalidated the rates that were set by the commission on the first remand in 2018-68, did not say to the commission, the rates that you approved were illegal, did not direct the commission to change those rates or to make alterations to those rates, but in both instances, on both appeals, directed the commission to conduct de novo hearings. De novo means new. De novo means new evidence. As Mr. Gressett referenced, the Parker case, which was overturned by the Supreme Court on the first appeal, what the Supreme Court did was to say, when we send it back for a de novo hearing, you're going to hear new evidence. You're going to treat it like the new case that it is. And that's what the commission did. And in both of those remand cases, DIUC had the opportunity and in fact did submit additional expenses as part of its rate case that formed the basis not only of the first case, the first order on remand that this commission issued in 2018, but in the order that approved the settlement earlier this spring. And that's extraordinarily important. Mr. Gressett argues and DIUC argues that DIUC needs to be made whole going back to 2016, as if there was a rate that was supposed to be in effect back then. As I mentioned previously, the lawfully approved rates by this commission have never been altered. They were in effect until they were changed by subsequent order of the commission. And so the claim that going back to 2016 rings hollow in part because the rate that DIUC obtained this spring that applies, everybody at least agrees applies going forward, contained different expenses and different inputs than what DIUC sought in 2016. And that, those facts alone show that you can't be held whole or you can't be made whole for something you were never entitled to in the first place. You can't be made whole with rates that were established in 2021, not just because you would be going back and that would be retroactive rate making, but the basis for the rate that was approved this spring was a wholly different set of expenses and inputs. And as all of you know as commissioners, the rate-making process and specifically the revenues that are produced by a set of rates are a byproduct of the rate-making process, a byproduct of your assessment of, well, what are the assets that they propose to put in rate base? What are the expenses that are associated with the test year and outside the test year? Rates are not a revenue number. They are the end point of a process that considers all of those things. And so there is no way that you could take a rate that was approved and agreed to in 2021 and apply it going backwards to 2016, in part because those inputs that produce that rate in 2021 are completely different. And just to follow on the idea that the proceeding was extended extraordinarily for, I think the term was events outside DIUC's control. DIUC exercised a great deal of control because both of those remands from the South Carolina Supreme Court specified that the commission conduct a de novo hearing. In each of those instances, DIUC could and did modify its rate case request to add additional expenses to indeed recover more in several categories of expenses, and I've included these in my brief and in the proposed order too, that made that request different from what was filed in 2015, and gave DIUC the opportunity to better itself through the process. Likewise, DIUC used those de novo hearings, and there's nothing wrong with that. Nothing wrong with this to advocate for certain plan and service to be included in its rate base, something that it has not ever been entitled to. So the idea that other parties, like the interveners, exercising their rights to conduct a de novo hearing, to present witnesses, to make arguments, that somehow is inappropriate and entitles DIUC to relief that is specifically prohibited by South Carolina law, also rings hollow. All the parties were conducting themselves and in conformance with the Supreme Court orders that said, Commission, go back and consider this again. Finally, and then, all of these things are set out in the brief and the proposed order, there were statutory mechanisms that were available to DIUC, in addition to the ones that I've already mentioned, that show that DIUC was not handcuffed by this proceeding that took place over a number of different appeals, that it had opportunities. As I mentioned before, DIUC bonded its rates after the first case in 2015, which meant that it implemented the rates of seeking 108.9% increase in revenues, put those into effect under bond pending the first appeal. And after that first appeal, when the commission conducted that first remand, all of the things that were mentioned in the Supreme Court's opinion, the water tank being in the rate base, bad debt expenses, and other income taxes, those were approved by the commission on remand and encapsulated in the rate that the commission put into effect on remand, which meant that those things, DIUC got the benefit of all of those things being in their rates from having bonded their rates on that first appeal. And the bonding statute itself embodies and shows why rate making is prospective, because it says to an applicant or a utility, if you don't like the rate you get from the commission in your case, you can put what you wanted, you can put what you sought into effect under bond during the appeal, subject to there being refunds and interest if on remand the commission gives you something less than what you asked for. But that is the statutory mechanism that's available to utilities like DIUC and gives them the ability to protect their rates on appeal. Absent that, and it's obvious from the statute, if you don't bond your rates, if you don't take advantage of that mechanism, then you will have those rates in effect unless and until the commission changes them on remand after appeal. Or, as another mechanism, and as this commission knows, a utility has the opportunity to come in for another rate case request within a year after one previous one. And as this commission well knows, there's a company that you're familiar with, Blue Granite, that used to be Carolina Water Service. In the same time that this case has been pending, and I'm not comparing the cases, believe me, I'm not comparing the cases because they've involved lots of different things, but in that same time span or less, Blue Granite's been in 3 times with 3 separate dockets and 3 separate rate cases. That is a mechanism available to DIUC in addition to the bonding mechanism. And finally, and I know I said finally already once, but the argument that DIUC has been deprived constitutionally of its rights, and echoes of Hope Natural Gas and Bluefield, cases that this commission is familiar with, that also rings hollow because those arguments about whether a rate of return or whether that return to investors as opposed to the effect of excessive rates on customers, those issues are considered within the context of the rate case itself. And that's been made clear in part because this commission's orders reference those standards in Bluefield and Hope Natural Gas. And it's clear, and from the Southern Bell cases and others, that that's when those questions are considered within the framework that I talked about of rate setting, about are expenses valid, are out of test year extraordinary events proper, is a rate base, is a return on equity excessive or reasonable. It takes place in that context, in that specific instance. And remember, the rates that have been approved by this commission in this docket most recently are final. They are final. Those rates cannot be appealed. So the issue of confiscatory and low or high or violating due process has to take place in the context of arguing and litigating those rates. This proceeding may be open to have oral arguments about whether or not DIUC is entitled legally to reparations, but those rates are final rates because they were not appealed. And so issues of whether they or the previously approved rates, which are also final, whether they are somehow inadequate or confiscatory or constitutionally insufficient, because those rates are final, those issues are not before this commission, and they can't be litigated before this commission at this point in time because those rates are considered just and reasonable. So just to sum up, specific South Carolina law makes clear that this relief is inappropriate, and that it shows that going backwards and trying to change lawfully approved rates is specifically prohibited by South Carolina law. But even if you view it through the idea that maybe the law didn't didn't consider something, or the law, created an anomaly or an unfairness to DIUC. The facts and the procedure show just the opposite in this case, that at every stage, DIUC had the opportunity to recover additional legal fees, to recover additional consulting fees, to recover the costs of the bond that it had in the first case, to, at each stage, add additional expenses and to litigate for its actual and potential benefit throughout this case, and mindful of the fact that they have the opportunity to come in and seek a new rate case and are not handcuffed. And so nothing that the interveners did in this case was improper or in any way would support the kind of relief that they're seeking and that DIUC is seeking. And I apologize for kind of stem winding there, and be happy to answer any questions that any of the commissioners have.
Thank you, sir. Office of Regulatory Staff.
Thank you, Mr. Chairman, members of the commission. Andrew Bateman with the Office of Regulatory Staff. Mr. Chairman, counsel for DIUC, Mr. Gressett, discussed a bit of the procedural history of this case, and it certainly has been a lengthy case. It's been a relatively complicated case, but we're here this morning to discuss one single issue, and that is the what DIUC has called the reparations surcharge that it seeks to implement on its current customers for past services rendered. Now, make sure you get that. It wants to implement this reparations surcharge on its customers today for services rendered in the years past. With that, Mr. Chairman, I think I'll jump into something that I think is relatively non-controversial, and that's just sort of the principle underlying the prohibition on retroactive rate making. The principle is that retroactive rate making is prohibited based on the principle that customers who use service provided by utility should pay for its production rather than requiring future customers to pay for past use. Now, this is the very thing, the very definition of what DIUC is attempting to do in this case. It's attempting to have its current customers pay for past use rather than production going forward. Now, Mr. Pringle talked about this a little bit when he talked about rates being prospective. That's not what DIUC is trying to do. Now, next, that doesn't end the analysis, though. We need to look, well, are there exceptions to this? DIUC has argued that because this case has been appealed, it's gone to the Supreme Court, it's been remanded, that rates haven't been final. I want to make very clear for this commission, in DIUC 2, the Supreme Court never made a ruling that the rates that this commission ordered in order number 2018-68 were unlawful. As a result, those rates at that point in time when this commission ordered them, and remember, this commission is the sole body with the authority to set rates. No one else can do it. It's this commission. When this commission set rates in order 2018-68 and the Supreme Court declined, I would say intentionally so, declined to rule that those rates were unlawful, it meant that those rates were lawful and final. You cannot now go back and seek to place this reparations surcharge based on lawful and final rates. That's the very definition that's prohibited, or that's explicitly prohibited by the very definition of retroactive rate making. Now, in their brief, DIUC raised the case of Ham v. Central States, and I'm glad that they did, because it shows really the contrast between that case and what we have in this situation. Mr. Chairman, if I may really quickly approach the substitute Elmo, I've highlighted a couple sentences out of that case that I think are important.
Yes, you may.
Thank you. Yes, ma'am. Well, I need to. Oh, I see. Thank you all so much. Mr. Chairman, as Melissa brings this into picture, and thank you so much. Thank you for allowing me to put this up there. This is a printout of the Ham v. Central States case, and I've highlighted two sentences that I think are helpful to illustrate the contrast between that case and what we have here. It says, under the present facts, and this is the present facts of the Ham v. Central States case, the rates approved by the commissioner were found to be unlawful. We don't have that here. The Supreme Court never made that finding. Now, just as important, the second sentence, as such, because those rates were found to be unlawful, a refund in this instance would not be considered retroactive rate making. Again, we do not have that situation here. The Supreme Court never found the rates ordered in order number 2018-68 to be unlawful. As a result, if this commission were now to allow this reparation surcharge, it would be the prohibited retroactive rate making. Now that's the first and primary reason, and I think really a dispositive reason why this commission can't allow this reparation surcharge, but it's not the only reason. Honestly, there are a multitude of reasons. Next, and we really only came about with the second reason, the secondary reason, subsequent to entering in the settlement agreement. But in the settlement agreement, DIUC agreed that the rates charged as of March 1, 2021 are just and reasonable. Now, those rates are just and reasonable as agreed to by DIUC, as ordered by this commission. They're final. They weren't appealed. So that's another reason where we have lawful final rates now in effect that DIUC can't seek to overturn by adding on top of it a reparation surcharge. So that's certainly a secondary reason why this would qualify as improper retroactive rate making. It's not the primary reason, but it's an additional reason. Now, on top of all this, as Mr. Pringle discussed, DIUC actually has or had a statutory remedy. South Carolina Code Section 58-5-240D allows utilities to put rates into effect under bond during the pendency of an appeal when they don't believe that the commission has ordered just and reasonable rates. DIUC is certainly aware of this remedy. They utilized it on the first appeal. They did not utilize it on the second appeal. Now, they have asserted that the reason they didn't utilize it is because they couldn't afford to. But there's no finding from this commission or any other authoritative body which agrees with that. That fact was never put into the record to be litigated. So that's not a basis on which this commission could rely. But even aside from that, Mr. Pringle mentioned blue granite earlier. Blue granite, this commission is well aware, relatively recently attempted to implement rates under bond, and they weren't able to. So what did they do? They came back with another proposal. DIUC has declined to do that. They have not tried to implement rates under bond in any other fashion other than stating, we can't do it, we're not going to do it. Now, I believe it's Dawkins v. Bilo, excuse me, maybe Dawkins v. Ingle Markets, where it states that if the General Assembly creates a remedy and the utility fails via a statute and a utility or party fails to avail itself of that remedy, that's the sole remedy that entity has in seeking to be made whole. DIUC clearly has failed to avail themselves of the statutory remedy that the General Assembly created. Mr. Pringle talked a little bit about the interest, and I want to touch on that a little bit more. The General Assembly really created a balancing act. So the way this bond statute works, the utility puts rates that it wants to put into effect. They put them into effect under bond, and if they're upheld on appeal, then they're allowed to, keep putting whatever rates are just and reasonable into effect, and they're essentially made relatively whole. If they lose on appeal, then they've got to pay back the difference with interest. By doing this, the General Assembly has helped to create accountability for the commission, the utility, and the consumers. All parties have skin in the game. What DIUC has proposed in this instance is that they don't have to use the bonding statute that the General Assembly has proposed. They don't have to have any skin in the game. They can come back after the fact and try to recover monies despite never having availed themselves of the statutory remedy the General Assembly created for them. That's another reason why I believe that DIUC is prohibited from implementing these reparation surcharge. A third reason is that I don't believe that this commission has the authority to implement this reparation surcharge. It's a quasi-judicial body. It's an administrative agency which has the powers explicitly conferred on it by the General Assembly. It's clear that the General Assembly has not explicitly conferred on the commission the ability to award a reparation surcharge. There's absolutely no doubt about that. Now, DIUC has argued that this commission implicitly has the authority to award this reparation surcharge. I would argue that any implicit authority this commission has to be governed by the explicit authority that the General Assembly has given it. What do I mean by that? In 58.5240D, this commission does have some discretion as to what constitutes a reasonable bond. So this commission, we talked about it a second ago about potential other solutions when DIUC stated they couldn't afford the bond and they failed to put forward before this commission an alternative solution. This commission would have probably had some authority to consider other solutions. DIUC didn't do it, so this commission never had the ability to consider those. But even if you take it a step further, and I don't think that you could or you should, but even if, assuming for argument's sake, the DIUC said this commission has broad discretion to implicitly award this reparation surcharge, you still get to the same conclusion. And here's the reason why. DIUC agreed in the settlement agreement that the rates it's charging as of March 1 are just and reasonable. So there's no need for this commission to go any further. In fact, if this commission were to go further and award a reparation surcharge, it would be implementing rates that were just and reasonable plus. They would no longer be just and reasonable because they would be in excess of what DIUC has already agreed is just and reasonable. Now, for those reasons, it's clear, I believe, that DIUC cannot implement this reparation surcharge. But I do want to address a few points that Mr. Gressett raised, if you would permit me. He brought up the length of this proceeding, and it undoubtedly has been a lengthy proceeding. I want to echo, though, something that Mr. Pringle stated. DIUC has not been disadvantaged by the length of this proceeding. And that's clearly evidenced by the settlement agreement. DIUC in its original application, I think, sought about $95,000 in rate case expenses. In the settlement agreement, they got over $900,000 in rate case expenses. They have received the benefit of these lengthy proceedings. Now, another thing I wanted to mention, DIUC discussed about, well, actually, let me go back to the timing. They even at one point in time thanked this commission and ORS for timely attention to scheduling matters. Throughout these proceedings, DIUC's participated. Like I said, they've certainly received the benefit, and they've even at times thanked the parties for timely attention to scheduling matters. To now state that the time is the reason justifying this reparation surcharge just doesn't make any sense. But I do want to go to sort of their constitutional argument where they argued that they have been entitled to some of these expenses. We don't know the revenue amount on which DIUC bases this reparation surcharge. And here's what I mean by that. We know that it's about the $2.2 million. We don't know, though, if it's the $2.2 million originally applied for or the $2.2 million settled upon. But either way, it's illogical. And here's why. Let's assume that they're basing this reparation surcharge on the $2.2 million originally applied for. Well, we know in the settlement agreement that part of that $2.2 million originally applied for was the about $700,000 in rate base. In the settlement agreement, they voluntarily agreed not to seek recovery of that $700,000 that was part of that $2.2 million. So if they're basing this reparation surcharge on that $2.2 million, we know that doesn't make any sense. They certainly weren't entitled to it because they've agreed that they weren't entitled to at least $700,000 of that $2.2 million, all right? So that doesn't make sense. Now let's say they're actually basing this reparation surcharge on the $2.2 million that they settled upon. Well, that doesn't make sense either And here's why. That $2.2 million contains rate case expenses, some of which weren't even incurred until the third proceeding. And a large percentage of the other ones, over $542,000 worth, weren't just and reasonable until the third proceeding. Why weren't they just and reasonable? It's because DIUC didn't provide justification making them just and reasonable. Just because the utility has presented for recovery and expense does not make that expense just and reasonable. That expense doesn't become just and reasonable until the utility provides sufficient documentation underpinning that expense, justifying why it should be borne, why it should be paid for by the ratepayers. And we know, this commission knows, DIUC didn't provide that documentation until this commission required them to after ORS was forced to file a motion to compel. So we know that if it is the revenue applied for, it doesn't make sense because DIUC voluntarily abandoned recovery of about $700,000. And we know that if it's the revenue figure settled upon, that doesn't make sense because many of those expenses weren't incurred until relatively recently, and a large percentage of the remaining expenses weren't just and reasonable until relatively recently. So for DIUC to assert that they were entitled to this at any time until, I mean, they aren't entitled to it, but for DIUC to assert that they were entitled to these rates at any time prior to March 1, 2021, just isn't true. With that, Mr. Chairman, I'm happy to answer any questions. We'd respectfully request that this commission deny DIUC's request for the reparations surcharge. And thank you very much.
Any reply?
Yes, Mr. Commissioner, thank you very much. I tried to take a rather artful approach to my initial statements, but I want to be clear for the record. DIUC filed an application for a rate increase in 2015. The POAs and ORS got together, put something together they called a settlement agreement, successfully convinced the commission to approve it. We appealed that settlement agreement because it wasn't a settlement agreement and didn't involve us, and because it was not based on fact. The Supreme Court agreed and sent the case back. When the case came back, there was a discussion of rate case expenses. That was a significant portion of the appeal of the order on rehearing. And as the commission knows, on rehearing, the Supreme Court chastised ORS for its misconduct, for applying a retaliatory standard to the same receipts Mr. Counsel for ORS was just speaking about. And the Supreme Court sent the case back because ORS's harsher treatment, its misconduct, as the Supreme Court called it, so tainted your order that it had to be reversed. What they are asking you to rule is when ORS takes a position found to be wholly unaccepted by the Supreme Court, which reverses it, and then on remand, when it engages in retaliatory misconduct resulting in another appeal and reversal, the utility should just be glad that after that misconduct, before a third rehearing, ORS was willing to settle for, are you ready for this? Allowing the utility to recover all of the rate case expenses, well, not all of them, allowing the utility to recover rate case expenses that the utility spent trying to keep up with this whole process of appeals. That's new costs. So this idea that the settlement agreement provides some advantage in reference to the original application amounts is just not accurate. counsel for ORS, Mr. Bateman, explained that the problem with retroactive rate making is when customers who use a service should be the ones who pay for it. The utility has kept records. It has records and is simply asking that the specific customers who use specific services but only had to pay a small amount of money in direct contravention of the utility's constitutional rights be required to pay an appropriate amount, and that they not have a windfall because the lawyers for ORS, sorry, not the lawyers for ORS, because ORS and this process has been extended for 6 years. Current customers who used current services would be charged for those services. That is what Daufuskie is asking for. Now, there was a lot of discussion about whether the order on rehearing was declared unlawful by the Supreme Court. I won't repeat all the descriptors used by the Supreme Court. The Commission can go back to the order, but it is certainly clear that the Supreme Court was telling everyone the order was so tainted by the harsher treatment of the same invoices on remand, ORS's position, that it had to be reversed. I don't know what more the court could say. With regard to the bonding on appeal, first of all, the bond statute is not a remedy. So to argue that the Supreme Court has provided some sort of specific remedy is not applicable. Second, remember, this utility was going broke because it had only a 43% increase in the original order. It couldn't afford to continue to pay the bond while it pursued rehearing an appeal, which we know on the backside of was the result of retaliatory improper conduct. So the idea that we have a statute that could have protected us, even though there are all these other things going on that are not proper, it's illusory. The Commission certainly doesn't want to rule that ORS, through intention or not intention, can benefit from protracted legal proceedings when its positions are repeatedly rejected by the court. I understand that Blue Granite made multiple rate case or rate application filings during the pendency of another one. Well, I would argue that encouraging another utility to be like Blue Granite is not the best position to take. Realistically, when a utility like Daufuskie is struggling to pay its bills and it faces an option of getting a bond and it cannot, and it submits proof to the Commission through affidavits that it cannot, and the reason it spent all its money is because it's been going through an appeal based on rejected positions by ORS and ultimately in the middle of retaliatory actions. In the real world, it costs money to run a utility, and if you are only getting 40% of increase, when ultimately the Supreme Court and this commission have said 88 was appropriate, and now we have an agreement for more than that, the utility can't afford to get a bond. And surely the commission doesn't want to say that that remedy included in the statute, it's not a remedy, but that it is a remedy included in the statute, and therefore if you go broke trying to defend positions, then you're out of luck. And when we finally get on the other side of rehearing and the Supreme Court says, wait a minute, this is improper retaliatory misconduct, we're not going to do anything about it. The utility just has to bear that burden. Finally, the idea that DIUC has not been disadvantaged because it's been able to reach this settlement agreement is just wrong. As there was a lot of discussion about the various components that go into a rate, what got the settlement done on the third hearing was that there were so many rate case expenses that had been occurred that ORS allowed those to be recovered now such that they could be incorporated into these rates. The utility wouldn't have had those costs but for the retaliatory misconduct that tainted the order and the previous positions. So it hasn't been made whole. It hasn't been brought even. It was punished and then allowed to get a little bit back. If we follow the logic of what the opponents are suggesting, it is a request that this commission rule that when a utility initiates an appeal, initiates a rate application, even if it is forced to pursue 2 appeals, rehearing, and there are the kind of significant findings as the Supreme Court has made in this docket, that the commission is powerless and or, if empowered, should not act to protect the utility. It's just not right. And I don't think when you look at retroactive rate making, current customers are going to pay their share for costs they incurred. They will not be allowed under our request to have a windfall. The utility will not be punished for having pursued appeals instead of refiling cases. Because the other logic is, if you come to ORS with your application and they take an outrageous position that results in an outrageous decision, don't appeal. Just file a new case. But the problem with that is every order that gets entered based on those positions of ORS come back to haunt you in the next case. You have to appeal, or else the findings of that order become the findings you are stuck with in the next case. DIUC had no choice but to appeal when it did and how it did. And it shouldn't be punished when the commission has the authority and the right within this ongoing proceeding to remedy the problem. And that's what the utility is asking.
Commissioner questions for the parties? All right. Oh, absolutely. We're in recess until 11:10.
Thank you, sir.
Good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2014-346 WS. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Caston, Thomas, and Powers. Joining us virtually, we have Commissioner Irvin. Commissioners, are there questions for the parties?
Chairman Williams.
Commissioner Caston.
Good morning, Mr. Gressett. If it's okay, I'd like to ask you a question or two.
Good morning, sir.
Good morning. I wasn't here 6 years ago, so I don't have the benefit of all that, I suppose. But something I do think a lot about with any utility, every utility, and I'll ask you if you know the answer to it. Is DIUC an efficient and economical managed utility?
Yes, sir.
And how would I know that? I mean, are there verifiable, tangible metrics? I mean, and I don't doubt it, but I'm just curious. How would I know that, or how would the commission know that? Based on what?
Well, there are two ways. One would be some sort of submission that, folks could gather up and prepare today. The other would be the sources that are included in the record of the case. In the first case, there was discussion about how the utility was run with regard to some Guastella Associates contracts and costs. In the record is a large report outlining the capital improvements and management steps that Guastella Associates took when it began managing the utility. And I would believe that in addition to the matters contained in the record of this case, that there are likely regulatory filings and other documents from which one could glean the utility as being well managed.
All right, thank you. And I'm not sure I heard you say this, but I kind of wanted to really see what you thought. Relative to the 6-year time frame, I guess the however long it's been that this has been occurring, are you saying that this time frame is exclusively caused by ORS and the interveners?
There are systemic time periods, right, and delays that occur through no fault of anyone, scheduling, commission, or court requirements outside of this case. It is the utility's position that the positions taken by the interveners and ORS in the initial, what was called settlement agreement, followed by the increased standards applied upon remand by ORS, unnecessarily extended the case.
So was that, it's still all their fault, or was there?
I believe that the utility's position is that given all circumstances it is fair to say that ORS's positions and litigation approach in conjunction with that of the POAs unnecessarily extended the case.
Okay, thank you. A couple more questions and I'm through. When all was said and done, there was a new rate case hearing that did occur, correct?
There was initial rate case hearing, and then there was an appeal and a hearing on remand. Yes, sir.
And did DIUC, did they modify any inputs, expenses, et cetera, in the new rate case hearing?
In the rehearing, yes, sir. They put in additional rate case expenses for recovery. In the first case, utility estimated its rate case expenses and was planning to stick to that number. I think it might have been $190,000. After having to go through the appeal and back down to rehearing, giving the court's instruction that it could present additional evidence, the utility put in evidence of additional rate case expenses incurred beyond the number it had estimated when it filed the petition.
And that was included in the, what was that, March 2021 hearing? Or?
Oh, no, sir. That would have been in the 2017 hearing.
Okay, okay. All right. That's all the questions. I appreciate it. Thank you so much, Mr. Gressett.
Yes, sir. Thank you. It's good to see you.
Commissioner Williams.
Thank you, Chairman Williams. Mr. Gressett, good morning. Good to see you.
Good morning.
I've got a couple of questions, and one is, would you talk some about the South Carolina authority or precedent or judicial cases that specifically relate to reparations from South
Certainly.
Carolina?
Certainly, Commissioner. There are no South Carolina cases directly on point with regard to the issue that is being presented in this case. There is some case law in addition to the change we referenced from the first Supreme Court ruling that instructed parties that they could raise additional evidence on remand. There's also, and I can see if I'll be able to put my finger on it in the proposed order.
Mr. Gressett, did what you just referred to about additional evidence, did that relate to reparations?
It did not specifically relate to reparations.
Thank you.
The
Sorry to
utility's
bother you.
position. Oh, I'm sorry.
Sorry to stop you, but just wanted to ask the question while it was in my mind.
Sure. The utility's position is that if a case was over, then the Supreme Court wouldn't be telling us that we can present additional evidence on remand. And if, as the opinion states, it specifically refers to financial condition, we believe that if faced with this issue on appeal, the Supreme Court would say, what we are asking for is a correction of the errors included in the 2018 order.
Thank you. My other question has to do with the interesting exchange that I heard regarding how you would be confident and be clear that DIUC was only charging those people who receive the services during the time that you're asking to recuperate the reparations. can you please talk more about how you're confident of that? Because, we all have a hard time going back and figuring out, exactly, who, what, and when. And then we're talking about going back as far as 6 years ago. And is there a place in your proposed order that you go into that detail?
The utility has been tracking the accounts and can specifically produce for ORS or the commission's review a spreadsheet demonstrating who paid what and what the additional charge would be per account by usage or fee. Those amounts are not calculated and filed with the proposed order because, as Commissioners aware, depending on when this all resolves, if it resolves tomorrow, right, we calculate the numbers and can hand in a spreadsheet. If we are discussing what the potential number is, we have to consider how long an appeal might take and when the furthest time would be. And so those numbers are estimated. If it would be helpful for us to select a date and provide that, we can do that.
I appreciate that. That wasn't what I meant to be asking about. It was more the details of how you track the specific accounts and more about the confidence and whether that aspect was addressed in the proposed order.
There is not in the proposed order a finding of fact that the numbers have been adequately or properly tracked. There is a provision and procedure which the parties agreed to as part of the settlement agreement and that would be incorporated into an order that says, if the commission agrees and orders X is allowed to be applied as a surcharge, before doing that, the utility will provide its information to ORS. ORS can review it. If it has questions or concerns that the parties couldn't work out, it would then, I think, come to the commission for a clarification.
Okay. So what I heard you say is it's in the settlement agreement, the
Yes,
details of how you would do that.
Yes, and also in the proposed order.
Okay.
Submit the calculation of the amounts of surcharges for each individual customer for review by ORS. Within 14 days, ORS would notify the commission if there is any dispute as to the amount of surcharge or their implementation.
Would you do me a big favor and tell me what page you're reading from?
Yes, ma'am. That is the Daufuskie proposed order on reparations at page 48.
Ah.
Last thing.
So there's nothing in here that talks about this gives ORS the opportunity to review the data so that they are confident that it is specific to the customers who were customers at the time.
Yes.
Fair enough?
Yes.
Okay, thank you. No further questions.
Mr. Chairman,
Commissioner Urban, then Commissioner Powers.
thank you. Mr. Gressett, how are you, sir? It's good to see you.
Good to see you, sir. Thank you.
Would you agree with me that the Public Service Commission is a creature of the General Assembly, and our authority is solely set out in statute?
I would agree that the commission is a creature of statute established by the General Assembly and that it has specific powers and also implied powers. Those implied powers under the case law should be interpreted broadly when the mission of the agency or the commission here relates to health and welfare of the public. So I think the answer is created by statute with specific mandates that are to be interpreted in such a way that in order to accomplish its goals, it needs certain implied powers, then they are present.
Is there anything in our statutory scheme that would authorize us to approve a request for reparations or surtax, as you've called it?
Well, I think generally the commission has the power to set fair and just and reasonable rates. What we're asking for is a correction of the 2018 order wherein only 88.5% increase was allowed. And so what we're saying is we agreed to a settlement preserving the right to request that the commission deal with this outstanding issue, which is a correction of the 2018 order applied to the parties that used the services under the rates set forth in that order.
But I guess you would agree that there's no explicit statutory authority that authorizes the commission to order reparations in a given case. Do you agree with that?
Yes, sir.
Okay. Would you also agree that the two rate cases that were heard by the commission, the rate increases that we granted were affirmed on appeal?
No, sir.
All right. Which one was reversed and remanded? The first one?
Both of them.
Okay. But the rates that we found in those orders were fair, just, and reasonable, correct? Were they not remanded for other reasons?
They were remanded because the first case, I think we can say, is because the adjustments included were not supported by fact, and the court reversed and remanded for rehearing. And in the second case, the conclusion was that the commission needed to evaluate the evidence and carry out its important responsibilities consistent within the objective and measurable framework the law provides. That relates back to primarily the Guastella invoices that the court found were approved by ORS and the commission in the initial order, but then subjected to a higher level of scrutiny on rehearing and rejected.
Okay. Let me ask you this. If there's nothing in the record to support your request for an amount of reparations, how could you possibly ask us at this point in time to make specific findings of fact as to what those reparations should be?
Well, I think the calculation can be found, right? The court can find as a matter of fact that applying the time, amounts, percentages, etc., results in a calculation that as a matter of fact can be applied. It's appropriate under the law. And then the instruction would be for the utility, as it does, as the commission does in other orders, to prepare instead of, a rate schedule to submit after the order, we would be preparing a spreadsheet of some kind that demonstrated implementation of the order.
Which brings me to my next point, and that is, doesn't this fly in the face of retroactive rate making? The concept that that's improper under the law?
Well, no, sir, as, counsel for ORS and the POAs explained, the premise behind retroactive rate making is that you don't want to have customers paying for usage by other customers, right? So in this instance, we have customers whose usage was provided at an unconstitutionally low rate, which we are seeking to remedy specific to each customer. In other words, there should be for ORS to review and the commission a calculation for each account, what the difference would be, and a way to mathematically check that.
Let's go back to the point that, you raised earlier. You said the company didn't have enough money to post a bond, and implement rates under bond pending the, second appeal, I believe. Is that correct?
Yes, sir.
Counsel for ORS, cited the statutory provision that allows the commission to, consider, any factors that might relate to the amount of the bond, and your client didn't do that, right? You just said, you're just contending we didn't have enough money to file it, but you never asked the commission to consider a lesser bond or an adjustment or a modification, did you?
We had a bond in place after the first order, which had to be renewed once or perhaps twice. As it was coming due the last time, about the end of 2017, the bonding company would not renew it. And so we submitted that information to the commission. If we were not able to renew the bond, which the bonding company refused to do, I suppose the only option would have been to ask the commission to allow us to continue charging the higher rate, but without any security. Because remember also that the bond not only covers what was going forward, but also ensures payment of what's been collected in the past. And so we had to make sure that both past and future would have been covered. I don't know if we specifically asked for consideration of another mechanism. Don't think that we did, to answer your question more specifically. But I think that was because there was no option that would have worked.
My final concern goes to finality and fairness, and you know, these are other concerns that I'd like for you to briefly address. One is how many bites at the apple does a party get? You know, when they go up twice to the Supreme Court, get relief, and then they come back and enter a settlement agreement. Well, you know, where does it end? Because this has been going on for 6+ years. What's to prevent every party coming back and saying, you know, I've exhausted my appeals, but I still think I'm entitled to more, so I want reparations too. Doesn't that open Pandora's box? Just never be a finality to any decision that we make?
Well, I think there are sort of two ways to address that. One is, in this instance, we have a settlement agreement whereby all the parties have agreed to allow this reparations issue to remain in litigation within the case and potentially appeal. In a usual case, which this one was not, right? You know, in hindsight, we see that twice on appeal, the utility was found to be in the right. And so if it's not allowed to pursue this, then again, the result is, hey, if you go get an order that only gives a 43% increase and you need 108, utility, you should take that as it is and just file a new case, because otherwise, when you start backing up from how many bites at the apple, you might as well go right back to the first one, right? You know, we talk about opening Pandora's box and what might get out, but under the same logic, if you close the door to limit a second or a third appeal, then how is that different than closing the door on the first one? I don't think we could have a rule that says, if you file an application for rate increase and you don't like what the commission says, you may appeal once, because what would likely happen is, you know, the Supreme Court won't, when you go up on appeal, parse through everything and give you a new rate order, right? They always want to send it back. And so if they send it back and the commission, you know, it doesn't get it right, or the applicant disagrees, it would be unable to appeal. Because
Well,
that, oh, sorry.
Yes, sir. I'm not suggesting that we limit your right to appeal, certainly not. You have that absolute right. I'm just wondering out loud, where does it end if we allow parties, not just your client, but any party, to come back and say, you know, we've been to the Supreme Court twice, we've got relief, we even have a settlement agreement now that gives us additional sums for our appellate cost, attorney's fees, but we still think we're entitled to more. Seems like there's no end to that process. You get to appeal our denial of reparations, and presumably the Supreme Court could remand it back again. It's a circular situation, right?
Yes, sir.
So that's what you think would serve us well going forward, that kind of never-ending process?
No, Your Honor, but remember that in this specific instance, there are certain facts that have created what we could describe as the never-ending process, that are beyond the control of the utility and that are unusual. I think the court or the commission could rule in this case specifically limited to these facts. I think also there are sometimes just cases that are appealed multiple times. You know, we've been in the Supreme Court, I think 4 times on the Captain Sam's Kiowa case. You know, there are just some cases that go around until the parties come to agreement or move on.
I appreciate your responses and thank you for entertaining my questions. No further questions, sir.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Gressett, good morning.
Good morning.
Following up on Commissioner Williams and Commissioner Irvin's questioning, let's say we had statutory authority to set rates retroactively. Let's say I decided to go buy a house tomorrow on Daufuskie. My rate would be different than someone who's been living there 2018, 2019, 2020, because they would be paying this retribution or retroactive rates.
Attorney
No,
Gressett, are you with us?
Yes, sir, I'm here.
All right, I'm being told by our technicians that we're having some bandwidth issues, or that you are having some bandwidth issues. I've been told that sometimes if you close out of unnecessary browsers or windows, that it may help with the bandwidth.
I think that's, everything's closed. Is that any better?
Yes, sir. Thank you.
Oh, I'm sorry. Commissioner Powers, if you bought a house and moved on to Daufuskie today, you would be paying rate A, which is the same rate everyone who lives there is paying. If the commission were to grant the relief requested, then for customers that were using service during the period at issue, there would be calculated a surcharge one time. It would be sent with their bill. They would pay it once and then go back to paying the same rate you're paying.
So in effect, this commission will be setting different rates within the same rate class.
No, sir. Everybody would be paying rate A. Anyone who didn't pay rate A for their usage during the time at issue would make that additional payment.
Okay. Well, let's say I've been living at Daufuskie the last 3-4 years, and I decided I'm going to move to Sun City or over to Margaritaville and leave, and you send me a bill for this reparations, and I don't even live there anymore. Are you expecting me to go back and pay when I don't even live there?
No, sir.
So the best thing to do would be somebody to either move, or let's say I decided to just put the house in my wife or my son's name or something, and they would not owe the reparations, would they?
I understand your illustration to question if a different individual owned the property, right? If it was an arm's length transaction and you sold it to someone else, of course, that new party would not owe it. If you decided you wanted to deed the property to someone else in order to avoid this utility surcharge, I think that might implicate some other issues.
Sounds like some of that would go into that Pandora's box that Commissioner Irvin mentioned. All kind of legal things that can come up.
Well, remember what we're asking the commission to do is to correct the errors in the 2018 order such that the utility is not deprived of constitutionally sufficient rates for that period.
And you can't tell us what the amount would be that would be the surcharge for each individual ratepayer at this time?
No, sir, because it would depend on their usage during the period.
Okay. Thank you, Mr. Gressett. Thank you,
Yes,
Mr.
sir.
Chairman.
Commissioner Caston?
Actually, Mr. Bateman, and I promise you, I'm not trying to kick the hornet's nest. But, Mr. Gressett, in response to, actually, I don't remember what question. And I do not really remember, what was in the Supreme Court decision. But, Mr. Gressett basically accused ORS of misconduct. that tainted the order. Did ORS commit misconduct in any of these proceedings?
Commissioner, I'm glad you raised that question. It was something that honestly I felt compelled to respond to, and I appreciate the opportunity to respond to it now. I do want to state ORS took that allegation and takes that allegation very seriously. We do. We take it very seriously. And we respectfully disagree. We don't believe that ORS nor the commission acted with any retaliatory conduct. And I can read to you the final bit of that order if it would be helpful in this situation, because again, we are here to discuss whether the reparation surcharge that DIUC is seeking is appropriate. And it is unequivocally prohibited if it is retroactive rate making and there's no exception. And it is retroactive rate making without an exception if the previous rates the commission ordered in Order 2018-68 were final and lawful rates. And those rates were final and lawful unless the Supreme Court said they were unlawful. And here's what the Supreme Court said. In this reversal and remand, we do not address the merits at all. We do not intend, let me read it in quotes, sorry, I skipped a couple words. In reversing the commission twice, we do not intend to make any suggestions of our views of the merits. Rather, we simply require the commission and ORS evaluate the evidence and carry out their important responsibilities consistently within the objective and measurable framework the law provides. The Supreme Court very clearly, and I think intentionally, did not order or state that the rates the commission ordered in 2018-68 were unlawful. As a result, those were final and lawful rates. What DIUC is trying to do now, going back and setting a new rate based on final and lawful rates, is the definition of retroactive rate making. But to answer your initial question, I heard what Mr. Gressett said. I appreciate you raising the question. We take that allegation extremely seriously, and we respectfully disagree. We don't believe that ORS nor the commission acted with any retaliatory conduct.
Well, this is probably for you and Mr. Pringle. Mr. Gressett states that DIUC pretty much, and I don't want to put words in your mouth, Mr. Gressett, but it pretty much blames the interveners in ORS for the 6-year delay. Take turns. You can answer it as a group any way you want to.
And I appreciate you raising that again, Commissioner Caston. Mr. Gressett has certainly blamed, I think largely ORS, but to some degree the interveners as well, for the lengthy nature of these proceedings. You know, I set forth in the proposed order that we submitted a number of different tables. Each of those tables highlights what these proceedings looked like. And I've gone through and literally highlighted with Word where a party requested an extension. I'm happy to put this on the substitute Elmo, though to be frank, it takes up a number of pages. So if that would be helpful, I'm happy to do that. Otherwise, it's in the proposed order that we submitted. But as you look through this, you will notice that DIUC is actually the party responsible for requesting many of these extensions. On the exception, when it was ORS or an intervener who did request an extension, DIUC, I don't think they once opposed. Not once. And again, I'll reiterate that, let's see, let me cite you to the exact instance, but it was in this recent third proceeding where DIUC even thanked the Commission and ORS for their timely attention to scheduling matters. I'll quote this. This is a letter filed by DIUC on December 16th, 2019, where Mr. Gressett stated, on behalf of my client, I thank the Office of the Clerk, the Commission, and ORS for their timely attention to the November 15th, 2019 hearing request. Now, ORS, we don't begrudge DIUC for requesting these extensions, but to then come back now and place the blame on ORS and to some degree the interveners for the lengthy nature of these proceedings, it's just not factually accurate. You can look through the dockets and you can see time and again when DIUC requested an extension. And again, ORS, we have no opposition to their requesting these extensions, but you can't then state that it was improperly lengthy because of ORS. And again, I mentioned it earlier, I'll mention it again. DIUC certainly received a benefit from these proceedings. With that, I'll turn it over to Mr. Pringle. I'm sure he's got something to add.
Commissioner, may I briefly respond?
We'll give you a chance. Let's hear from Mr. Pringle.
Yes, sir. Thanks.
Commissioner Caston, the exact statement is that the POAs and to some extent ORS unnecessarily extended the proceeding. That is categorically untrue. There is nothing that would support that proposition. On the initial case, the settlement agreement that was reached between the ORS was something that DIUC knew about. And even if they hadn't known about it, and even if all of that is, we tried the case at the commission. There was a settlement agreement involved, but every single witness appeared. Every single witness was subject to cross-examination. Every single witness was subject to questions by the commissioners. The case was conducted exactly like every single rate case that this commission has conducted. Moreover, that posture did not extend the time that rate case took. That rate case was conducted within the 6-month time frame that's specified in Title 58. Furthermore, obviously the appeals, the interveners could not have been responsible for any of the time that took place on the appeals. And remember, the Supreme Court said twice, we remand this for a de novo hearing. That means the opportunity to again present witnesses, to conduct discovery, to try the case again, and that any party would have the chance to do that could not be construed as delay, not only because we were just exercising our rights under the Administrative Procedures Act and 58.5.240, but because DIUC did exactly the same thing and continued to advocate for things that it never actually received at the end of this case. This was not a situation where they were just trying to get something they sought in the first instance. They came back for more. They sought and received additional expenses. They continued to advocate for plan and service that this commission never approved. I'd also point out that 2018-68, there were 2 commissioners who dissented and took the intervener's position with respect to some plan and service being construction in aid of contributions in aid of construction, so put on a good case. Moreover, that particular order, 2018-68, was issued on an expedited basis to accommodate DIUC because of those bonding concerns that DIUC raised. And in particular, that order said, with respect to the $542,000 in Gostella and Associates consulting fees that were at issue, that DIUC could recover those expenses in a later rate case if they were able to provide to ORS that specific verification information that ORS sought. And you know what happened after the case was remanded from the Supreme Court? You know what happened? After ORS filed a motion to compel, DIUC provided the information to verify those specific invoices for Gostella and Associates, and DIUC was allowed to include those rate case expenses. In neither instance did the South Carolina Supreme Court make a determination that rates were unlawful. The lawful rates were as they had been approved by the commission. DIUC never had to collect a 43% increase because they bonded their rates From April 1st, 2016, they recovered 88.5% increase what was ordered in Order 2018-68. Finally, to the point about implied powers that Commissioner Irvin referenced, South Carolina law says specifically, I'm quoting SCE&G versus South Carolina Public Service Commission that's on page 5 of our proposed order. The commission simply does not have any implied power to award refunds in the nature of reparations for past rates or charges. Such power must be expressly conferred by statute. In that same case, the commission has no more authority to require a refund of monies collected under a lawful rate, which the rate approved in 2018-68 was a lawful and final rate, than it would have to determine that the rate previously fixed and approved was unreasonably low and that customers would pay the difference to the utility. And finally, on the issue of retroactive rate making, it's prohibited based upon those who use the service should pay for its production rather than requiring future ratepayers to pay for its past use. Future ratepayers, and this is why it sounds a little confusing, future ratepayers is the same person is also called in the future. I mean, it can mean somebody in 2021 as opposed to that same resident in 2017. What it means is the rate that you should pay ought to be based upon what is actually those costs that are close to and associated with those rates being produced in the rate case, not based upon paying something in the past based upon those same expenses, that rate-making process that you all oversee. So it is the quintessential example of illegal retroactive rate making that cannot disturb a lawful rate that's been established by this commission, and doing so would violate all of those things. And I object strongly to the idea that this was unnecessarily extended, because all the parties did exactly what you do in a contested case, a de novo case when it comes back. That's what the Supreme Court told us to do. That's what we all did for our benefit or our detriment, and all parties took the risks of going forward with that. And it cannot be something that is held against us and that could possibly form the basis for an order of any type, and specifically one that would adjust rates in this form or fashion, because, and this is the last thing I'll say, the whole idea of trying to graft a surcharge back to 2016 based upon a rate that was determined in 2021 based upon a set of assets and expenses that were submitted at that time is, by its very nature, arbitrary and capricious, because it does not match the inputs that go into making rates with the actual rate that results. And it runs afoul of these specific cases and the specific law not limited to 58.5290, which makes clear that when the commission can make changes to an existing water and sewer rate after a hearing, that it has to do so prospectively. And the Porter case that has construed that statute, as well as SC&G, as well as all the cases Central States and others make clear, is that if you have a legally approved rate that has not been determined to be unlawful, you cannot adjust it going backwards, because doing so would be illegal retroactive rate making. Thank you, and I'd be happy to answer any additional questions.
I have no more questions at this time. Thank you.
Attorney Gressett.
Thank you, sir. Whenever an application is filed, let's say an order is entered, and subsequent to that, the parties agree or the commission enters an order that modifies that rate application under the point that Mr. Pringle just made, all of those orders would be arbitrary and capricious because they don't match. I don't think that's a correct conclusion. With regard to lawful rates or unlawful rates, it is the utility's position that when the Supreme Court reversed the two orders, they were not final lawful rates. As long as this proceeding is open through the final appeal, the utility ought to have the opportunity to produce this information and have the rates be corrected. I would also go so far as to say, order of the Supreme Court, the first one, invalidated, reversed, and remanded the first order, as did the second order of the Supreme Court. I do not know a way to reconcile enforcing as lawful an order that has been reversed and found appropriate for remand by the Supreme Court. When this case came back from the Supreme Court for rehearing, ORS took the position that none of the Guastella Associates costs should be recovered, even though it had previously approved some. And the Supreme Court said, hey, that's a higher standard. You can't do that. Then when we came back on remand, ORS took the position that it was going to apply the heightened standard by requesting more information. And so the utility said, that's not consistent with the Supreme Court. And that issue took a long time for us to sort out. But I want to be clear about the utility's position on timing. Mr. Bateman's correct. Their proposed order has like 6 pages of calculating delays. At the most, that comes up to about, let's say at most, 210 days. 6 years is 2,100 days. So if it took 10% longer for this little utility to respond to the positions that were being taken, and it took 10% longer for the utility to be successful on appeal, that is not the same thing as ORS taking positions that exaggerate the length of a case. For example, its position on remand that it was going to apply what the Supreme Court rejected as a retaliatory standard to the Guastella Associates invoices. There is no way around that. That is what necessitated the appeal. That is what dragged out the second case, not anything that the utility did. But even if we look at this case and take all alleged animus or motivation out of it, because I want to be clear that I'm not faulting Mr. Bateman or Mr. Pringle. And I guess the thank you that I wrote in that letter is now coming back to haunt me for being polite. But I'll say again, they are good lawyers and we get along well. The problem is that if a case takes this long, something has to give. And when that something is the constitutional rights of the utility, that's the wrong result. The proper result is that we look at if we must call it extraordinary, super extraordinary, unique case that has no likelihood of ever being repeated on these facts only. It is clear that the fair and equitable, appropriately constitutional result is what the utility is seeking. I think that's all I got on
Sure. I know you got some more.
that. Might be done.
All right. Anything else from the commissioners? Parties, you've given very spirited arguments. I've enjoyed them thoroughly. Anything else before we adjourn?
No, sir. Thank you.
All right. We are adjourned.